Good morning, students, and welcome to our today's lecture on the Introduction to European Law. Last week we dealt with the European Competition Law, and today we are going to deal with the preliminary rulings of the ECJ or the National Court. Now, this procedure has to do with direct and indirect control. Now, when we say direct control, we mean that when the court directly checks on the legitimacy or lack of action of the EU and ends with a decision of the court's infringement procedure: action for failure to act, action for annulment, and action for compensation. Then indirect control means when the court is requested by a national court to interpret or assess the validity of an act of the European Union. Request for preliminary ruling is what we call it. Now, what are the purpose of these procedures? One, increasing number of cases before the national court concerning community law. Two, national courts may be faced with questions of interpretation of the community law provision. 3. National courts may seek a preliminary ruling on the point of law from the ECJ. 4. National proceedings are adjourned pending rulings from the ECJ. And 5. Interlocutory procedure. Article 267 of the Treaty forming European Union says that the Court of Justice of the European Union shall have jurisdiction to give preliminary ruling concerning A, the interpretation of the treaties; B, the validity and interpretation of acts of the institution, bodies, offices, or agencies of the Union. Where such a question is raised before any court or tribunal of a member state, that court or tribunal may, if it considers that a decision on the question is necessary to enable it to give judgment, request the court to give a ruling thereon. Where any such question is raised in a case pending before a court or tribunal of a member state, against whose decisions there is no judicial remedy under the national law, that court or tribunal shall bring the matter before the ECJ. If such a question is raised in a case pending before a court or tribunal of a member state with regard to a person in custody, then the Court of Justice of the EU shall act with the minimum of delay. What are the purposes of this preliminary ruling? 1. To secure uniformity in the interpretation of community laws. Case 1361, De Goes. For example, in this case, the court established that the progressive integration of the treaty into the legal, social, and economic life of the member states must involve more and more frequently the application, and when the occasion arises, the interpretation of the treaty in municipal litigations. The provision of Article 267 must lead to a real and fruitful collaboration between the municipal courts and the Court of Justice of the European Union. In case 166/73 of Rhine-Wahlen in Germany, Article 267 is essential for the preservation of the community character of law established by this treaty and has the object of ensuring that in all circumstances the law is the same in all states of the community. This was what the ECJ established in both two cases. Now, shared jurisdiction, National Court adjourns and questions submitted to ECJ. ECJ provides preliminary ruling to national courts. National rules on the facts and decides outcome of the case. No, an appeal is possible. Now let's talk about jurisdictions. When the issue of jurisdiction has to be yes, then the interpretation of the treaty or the validity and interpretation of acts of the institution, that is, interpretation of the regulations or directives or decision. When jurisdiction of the ECJ is no, then it means not the validity of national law or the compatibility of the national law with EU law. For example, in case 2662 Van Gent and Loos, or in case 6/64 Costa versus Enel, not on the application of the treaty and not on the facts of the case. Courts. 1. Only the national court or tribunal can refer to the Court of Justice. Individuals cannot. 2. Which court or tribunal can refer to the Court of Justice of the EU? All national courts, example, civil, criminal, administrative, or tax courts, has jurisdiction to refer a case to the ECJ. The constitutional judge can only refer to the court when he or she is the judge who decides on the issue. Like in the case of a decision concerning the unconstitutionality of a law. In that case, only that judge in whose court or in whose table this case is channeled can approach or refer a case to the ECJ. Other courts. Any court or tribunal that fits in this test: 1. Established by law. 2. Must be judicial in nature, that is, makes legally binding decision. 3. Inter partes procedure. 4. Have degree of permanence. 5. Be recognized by the state, some form of statutory origin, has jurisdiction to refer a case to the ECJ. If you don't fall in this 5 mentioned category of courts, then you don't have jurisdiction or local standing to refer the case to ECJ. Secondly, medical appeal tribunals has jurisdiction to refer a case to ECJ. For example, in case 2016/80 Broekmolen, that is Dutch Appeal Committee for General Medicine. And secondly, not an independent arbitrator. For example, in case 102/81 Nordsee Deutsche Hochschulgericht was accepted to have jurisdiction to refer a question or a case to the ECJ. When can judges refer? In what situations can any judge or judges refer a matter to the ECJ? 1. If that judge considers that a decision on the question is necessary to enable it to give judgment. 2. It's entirely for the national court to decide whether it is necessary to refer a case and also whether to refer that case to ECJ. So the courts have discretionary power to decide if it is necessary to refer a case to the ECJ or not. In case 16673 that I mentioned above, Rhine-Molen case, a national court cannot be deprived of its power to refer by rulings of a superior court. Also, in case 210/06 Kiatiso case, in accordance with Article 267, Trade Reforming European Union, the assessment of the relevance and necessity of the question referred for preliminary ruling is, in principle, the responsibility of the referring court alone. When judges must refer, remember the one above is when judges can refer. Now, let me repeat again when a judge can refer a case to the ECJ so that when we talk, so that we understand the word can and the word must. Now, when can a judge refer a case to the ECJ? They said 1, if that judge considers that a decision on the question is necessary to enable him or her or the panel to give judgment in that particular case, or it is entirely on the discretion of the national court to decide whether it is necessary and also whether it is not necessary to refer such case to ECJ. Then we gave 2 cases where it was found necessary that courts or judges should refer the case. And the first case we gave was case 166/73, Rhine-Molen case. A national court can not be deprived of its power to refer by ruling of superior courts. In other words, if a court is handling this case, for example, in the lower court, the appeal court cannot intervene. It is the duty of that lower court to refer this case directly to the ECJ. He doesn't have to refer the case to the appeal court or to the Supreme Court. He has that right to refer the case directly to the ECJ. Similarly, there was also the second case we mentioned, case 210/06, Kiatiso case. It says that in accordance with Article 267, Trade Reforming European Union, the assessment of the relevance and necessity of the question referred for preliminary ruling is in principle the responsibility of the referring court alone. Did we understand this? If we did, then let's now talk about when can or when must judges refer a case to the ECJ. 1. Where any such question is raised in a case pending before a court or tribunal of a member state against whose decision there is no judicial remedy under the national law, that court or tribunal must bring the matter before the ECJ. Did you understand this? Let me repeat it again. If there is a case in any court, in any member state, and in this case, there is no possibility of an appeal after the ruling, then in that case, you must refer the case to the ECJ to get a definitive decision on or answer to the issues that are being contested in that case. Secondly, abstract theory condition. The abstract theory condition that warrants that a judge must refer a case to the ECJ is when courts from which there is never a right of appeal is handling the case. For example, the House of Lords, which is the Supreme Court in the UK, or the Council d'État, which is like the Supreme Court in France. If a case is in its final stage that there is no remedy possible again, in that case, the court or that Supreme Court or that apex court of the national court must not decide, rather they must refer the case to the ECJ in order to get a complete and final stand in the matter being contested. Thirdly, concrete theory. This concrete theory gives another reason why a court must refer to the ECJ to get a ruling. This concrete theory says that whether there is no right of appeal in the type of case in question, so if there is no right to appeal, you don't have choice, the court doesn't have choice, the court must refer that question to the ECJ. Now let's talk about abstract and concrete conditions that I mentioned above and give example, a court case example where the ECJ ruled that yes, the court must or can refer. In abstract, the court decided in Bulmer versus Bollinger case that short of the House of Lords, no other English court is bound to refer a question. That was what Lord Dinning declared in the House of Lords. So here he established that the House of Lords is the final arbiter in the UK, and that is why the case has to be referred to the ECJ in order to get a final ruling on the challenged case in court. Now, concrete reason was also established in Costa versus Enel. National Court, against whose decision, as in the present case, there is no judicial remedy, must refer the matter to the ECJ. ECJ in relation to Italian Magistrate Court. This was how it was ruled in Costa versus Enel that we talked about when we were talking about the direct effect of the Treaty European Union in case Costa versus Enel. Now there is also case C9900 Leaks Kirchhoff. The court established that the fact that examination of the merits of such appeal is subject to a prior declaration of admissibility by the Supreme Court does not have the effect of depriving the party of a judicial remedy. Are we clear? Now, there are also some other cases like case 283/81 in Sealfit. The following were established. The case was before Italian Supreme Court. They call it in Italy the Cassazione. A court falling within Article 267, paragraph 3. The second one was the question in the proceeding had already been addressed by ECJ in earlier case. Again, was the Italian court still bound by Article 267, paragraph 3 to seek a ruling even where it had no doubt as to the meaning of the provision because the ECJ had already given a ruling? You see the difference between what we explained before and what I'm explaining now. In this case, 283/81, a case was tabled in Italy in the Italian Supreme Court, a case that has already been answered by the ECJ in another country. Is there any need for such case that is happening now in Italy to be referred to the ECJ again? It follows from the relationship between the second and third paragraph of Article 177, now Article 267, that the court or tribunal referred to in paragraph 3 have the same discretion as any other national court or tribunal to ascertain whether a decision on a question of community law is necessary to enable them to give judgment. So, it is saying now that, yes, it has been established that this case has been answered by the ECJ before. Is there any need for the Italian Supreme Court to refer that case again to the ECJ when the court knows that this case has been handled already by the ECJ in another case in another member state? So what the court concluded here now is what we said before, that a court must use its discretion before they could refer a case. For example, here, maybe it was a similar case, but the issue or the legal issue being challenged is a bit different and complicated. The court knows the law, so the court has to either decide on this case based on or following the guideline that the ECJ used in the previous cases, Or they could also use their discretion, if confused, to send back or rephrase the question now to the ECJ in order to be able to get a concrete and definitive ruling by the ECJ. Yes, in this similar case, the questions that are challenged could differ. Then if the court feels that it is clearly different from the already treated cases by the ECJ, yes, they could refer. Now, this brings us to the principle we use here in the European law or European Union law, or in general, the principle that we call the acta clea principle or acta clea doctrine. Acta clea principle or acta clea doctrine means that when the wordings of the law is clear, there is no need to interpret. In other words, the acta clea doctrine says that when the application of EC law or EU law is clear, there is no need to refer to the Court of Justice. This was established in the above mentioned case above in the ECJ, the CFIT case number C283/81. This doctrine also exempts the judge who must refer to the court, because if after reading the previous cases and what was established by the ECJ in that case is clear, there is no point referring. This principle or this doctrine is mostly applied in the European law. We call it the doctrine of acta clea. Note, there is difference between doctrine acta clea or doctrine acta le clea. Doctrine acta clea is when the law is very clear, and doctrine acta le clea is when the law has been clearly interpreted. So you could get confused sometimes, but let us not go into details between this acta clea doctrine and acta le clea doctrine. Secondly, power of the ECJ to decline to decide cases. 1. The ECJ has power to refer the case back to the court in certain situations. 1. When the case is hypothetical, when the judge just wasn't sure what they were asking for, they were not sure of, when the judge or the court that refers the case is not being clear in the answer he was expecting, then the ECJ can refer the case back to the court and ask them, what do you really want? Secondly, when the question raised is not relevant to the substance of the dispute, the ECJ can refer the case back or decline to give opinion on the case. Thirdly, when the legal question is not sufficiently clear, when the legal question is ambiguous and unclear, the ECJ can reject it and send it back to the court that sent it to the ECJ. And also, where the facts are insufficiently clear, the ECJ can refer the case back and refuse to to comment or give a ruling. Therefore, if a court is sending a case or referring a case to the ECJ, the court must be very clear on what the disputes are, what they are actually expecting the ECJ to rule on. If not, the case will be returned back to them untreated. What are the effects of ECJ's decisions? The ECJ's decisions has the following effects. 1. When the court gives its interpretation, the national court must respect and enforce EU law according to the interpretation of court. That is why the decisions of the ECJ is very, very paramount. Secondly, the other member states shall take all initiatives needed to fully comply with such interpretation. We call it the loyalty principle. So when the ECJ rules, every member state must do their best to follow the jurisprudence of the ECJ so that the rulings in the whole EU will be uniform. Thirdly, when the decision concerns the validity of an act, 1. If the act is found to be valid, consequences are limited only to the context of the specific case. 2. If the act is found to be not valid, the act is therefore declared void and null. Other outcomes. 1. Through the preliminary ruling, the Court of Justice developed concept of seminal importance for the development of EU law, such as direct effect, indirect effect, and supremacy of the EU law. 2. Preliminary rulings are also an indirect way to test the validity of the European Union action for conformity within the European Union law. How did we go today? Please, if there is any question, do send me an inbox message or just go to send your message. However, I will try my best to answer more of them to make it a bit clearer. But before we end today's lecture, let us go back to the other outcomes of the rulings of the ECJ. We said that through the preliminary ruling of the ECJ, the Court of Justice develops concept of seminal importance for the development of EU law, such as direct effect, indirect effect, and the supremacy of the EU law. Finally, we said that preliminary rulings are also an indirect way to test the validity of the EU action for conformity within European Union law. Thank you, students, for today, and I hope you go through the lecture. Just take your time, no hurries. Take your time, listen to the tape once, twice, 3 times, 4 times is possible. Our duty here is to make sure that you make your A's or B's in your first year at the university or during your master's program. Today's lecture was only the preliminary ruling and why it is important to refer cases to the ECJ before the National Court decides any case. I hope we are clear today, and tomorrow we are going to treat the EU actions for annulment. Until then, I wish you a nice day, and I see you soon tomorrow morning. Have a nice day, and bye-bye for now.